sir is there, I will hear the way, sir. Professor Ravi Kumar sir is there, I will hear.
Well, probably the state may have to start the matter.
What state they have start the matter?
Well, any other.
Okay. No, if you are arguing, argue the matter. He has given judgment saying that nobody need be heard.
We'll show that the complainant also need not be heard in this matter because complainant also cannot choose the investigating.
Please do that. That's
Therefore,
all.
Manoj,
No adjournment, sir. It's specifically fixed today, no adjournment.
kindly
But, sir, it's not correct. See, I
Okay,
took consent of all of you and then
can I let the others argue, Manoj? Then we'll.
see this piecemeal battle. We finish it off.
No.
Who's there?
Mr.
Who's
Sibal
ready?
will be.
Dave sir is ready?
Yes, Manoj. I am ready.
Yes, sir. You start, sir.
Very well. What this case doesn't depend on the law.
Manoj,
Law is crystal
I got
clear.
a message from Mr. Sibal saying that there's some problem with the connectivity, Manoj. That's
No problem. Let it, you reconnect.
no, there's.
By the time Dave sir will be on. Yes, sir.
May it please your lordships.
Yes, sir.
My Lord, this writ petition deserves to be dismissed summarily. It is a public interest litigation. My distinguished friend, Mr. Maninder Singh, has cited a lot of law. My Lord, most of that law is in the context of, my Lord, deprivation of lives of innocent citizens and shoddy investigations conducted by the police. And therefore, the court felt, as a constitutional court, that yes, the investigation should be transferred to the CBI. That case has nothing to do with, my Lord, the facts of this case. My learned friend has, my Lord, singularly failed to point out to your lordships the relevant facts necessary for, my Lord, even entertaining this writ petition, prima facie.
Yes.
I respectfully submit this petition is an abuse of the process of court. It deserves to be dismissed on several grounds.
Yes,
First
sir.
and foremost, on the ground of delay. Second, on the ground of acquiescence and estoppel. And third, on the ground that having chosen expressly a remedy which you claim to be independent, you can't now be allowed to reprobate and approbate and say, now please direct in exercise of constitutional powers that investigation be done by another agency. So, my Lord, whichever way your lordships looks at it, my Lord, I respectfully submit that this case requires a very deeper examination by your lordships before your lordships even come to a prima facie conclusion. The judgments, my Lord, are of no relevance with great respect to my learned friend. The judgments are in entirely different situations. The fact situation of each of those cases were different. We are dealing now with a case which is very separate from those facts. These facts don't necessitate any investigation by the CBI. Now, my Lord, I am appearing for respondent number 12. And respondent number 12, unfortunately, stands damned without being heard by your lordships in the first round. I was not a party.
Yes,
So, my Lord, I respectfully urge your lordships to give me an opportunity to persuade you that what, my Lord, was done was not in the right context and it is required to be determined by a competent court and not by a 226 court at this stage. Because if your lordships were to say anything about, my Lord, my involvement in any criminality, it is going to seriously affect my right in the trial.
May I interrupt? Dave sir. Now, on the facts of the case, you have filed an appeal. Appeal is now whether it should be referred or not, the judgments are there. Contra judgments, you give me the law. Then I will
No, Lord,
consider
with
it
great
and pass an
respect.
order.
No, it's not so simple, my Lord. Because your lordships have taken a view earlier, therefore, my Lord, that was in the context of challenge to a section 17A order.
Yes.
It has nothing to do with, my Lord, the criminality of the case. My Lord, the facts of the case, my Lord, whatever your lordships may have examined, they were not examined qua me. Qua me, therefore, my Lord,
that is true,
your
because
lordships can.
Because
Your lordship-
it was examined by the petitioner who was there.
Correct, my Lord. Now,
Yes.
so far as I am concerned, it is my respectful submission that there is no, my Lord, criminality, there is no, my Lord, prima facie case against me at all.
All right.
To proceed in a criminal case, much less, my Lord, by a CBI investigation. That is what I am going to, my Lord, prima facie show so far as I am concerned. Now, my Lord, therefore, your lordships may kindly turn to the complaint which has been filed before the Lokayukt court at page 240.
Page?
240.
Yes, sir.
Lord, petitioner assumes that your lordships have power and therefore that power must be exercised. Lord, petitioner has not been able to persuade your lordships and show prima facie that facts of this case justify exercise of that power, my Lord. And I will show to your lordship that facts as narrated by him in his own petition do not disclose any reference to a CBI investigation. Now, please kindly come to para 2. In fact, this is a gross abuse, my lord. Complainant is a public-spirited person and is a social worker who has pursued various causes in interests of society at large. Complainant is a well-known journalist, filmmaker, and a celebrated film director. Good, my lord. He gives himself a certificate. I am so happy. Now, my lord, kindly see the background of the case. This is very important. Here is a man who stands before a constitutional court, my lord, with all these alleged facts, but does not tell your lordships that why he could not dig out these facts 10 or 15 years ago. Why is it that, my lord, he suddenly digs out these facts in the year 2024 and approaches, my lord, the competent court? He is now standing before your lordships without any explanation whatsoever about delay. Now, my lord, if there is a delay in a PIL, then, my lord, that delay goes to the very root of the matter. Now, please turn to all this, my lord. Right from, my lord, paragraph 3 onwards, my lord, he has relied upon public documents. My lord, mind you, my lord, this is not a case where any document was suppressed by any authority. It is not even his case. He has simply presented as if these are readily available. He has found them and now he is telling the court that you start investigating.
What
So-
was the prayer there?
Yes, my lord, I'll come to that. I'll come to that. Just kindly turn. So, my lord, right up to para 30. Please see, my lord, right up to para 30. Your lord, will see right from para 3 to 30, various facts are disclosed. These are all, my lord, from the public available documents in public domain. Then, my lord, overacts by chief is accused, my lord, which I am not concerned about because that's against accused number one. I have nothing to do with accused number 1. Then, my lord, kindly turn to paragraph 53.
Yes.
The pertinent to note, complainant on earlier occasion had approached Vijayanagara police station, Mysuru, whereby they have issued acknowledgement. They refused to register an FIR. The complainant has given complaint to police commissioner, so-and-so, Lokayukt Assistant Director General, Lokayukt Director General, Inspector General, and also Central Bureau of Investigation in terms of section 154. Now, this is important. He has given all these complaints versus so-and-so, so-and-so. Said police have not taken any action, violated the guidelines of apex court in Lalita Kumari. Hence, complainant had no other go than to approach this honorable court. Mark those words, my lord. These words alone disentitle him from moving a 226 court. This is his expression of faith in the Lokayukta court. You cannot write 2 remedies, my lord, and your lordship should not permit, however much your lordships may be disturbed about the act of the chief minister. Lord, that's a separate domain. But here, look at the conduct of this man. Here is a petitioner who chooses a forum willingly, voluntarily, and that too after a great delay of more than 15 years. My lord, the saga begins as early as 1935 according to him, but 1968, 1991, my lord, where these alleged transfers seem to have taken place. I will deal with them and what he has suppressed before your lordship's court and, my lord, before the Lokayukt court as well. So, my lord, this sentence, the said police have not taken action, violated guidelines. Hence, complainant had no other go than to approach this honorable court. Now, this honorable court is the Lokayukt court. Hence, the present complaint, copies of the complaint filed by so-and-so are so-and-so. Then, my lord, he gives the affidavit. Then, my lord, para 55. Kindly see, since the accused one, present chief minister, is competent authority to accord sanction for prosecution is His Excellency the Governor. Accordingly, complainant has sought the sanction for permission under section 19, so-and-so, which is pending consideration. Since allegations against the named persons are not in relation to any action or recommendation made by accused one or other named accused, there is no requirement of prior permission, so-and-so. Furthermore, corruption, and now para 56 is important. Further, corruption and irregularities committed by accused one is just tip of iceberg. In fact, many government officials and others at the relevant point of time were actively involved in larger scam which needs deeper investigation, inquiry and trial. A complainant reserves right to bring. Now, my lord, just see this. Mr. Singh today is persuading your lordships that, oh, there is a serious case of corruption and highest level it is taking place. Therefore, you alone can direct CBI investigation, and CBI is the only independent agency which can investigate. No. His client, Lord, made a statement on oath before a competent court in para 56 that these cases require investigation by Lokayukt court and Lokayukt court alone. Then, my lord, para 57. Admittedly, accused one has served at the helm of affairs. Accused one has served as Deputy Chief Minister, Finance Minister. Hence, naturally, now see next statement. Hence, naturally, Police Department, Karnataka, and other investigating agency coming under control of government are refusing to take any sort of action. His family. However, complainant has furnished sufficient material to prove acts of criminal misconduct, corrupt practice, illegal practice, offences beyond reasonable. In this case, this court deems it further to investigate, inquire into assistance of investigation agency not under the control of state government may kindly be taken into account. Lord, this is the abuse of process of court. And when does he come, my lord? After your lordship's judgment. After your lordship's judgment, my lord, he moves your lordship's court, my lord, within a week to file a CBI transfer. Your lordship should not invest your precious judicial time in these matters. Throw him out at the threshold and say you have chosen a remedy, go and satisfy there. Now please see, para 59. Accused one is a member of Legislative Assembly and offences alleged are triable by special court. Please see this. Are triable by special court under PC Act, and hence this court has jurisdiction to entertain complaints, secure all accused, punish them. Complainant has not filed. And therefore, my lord, he says, take cognizance under so-and-so prayer, please see, prohibition so-and-so, hold and inquire or direct CBI, any independent agency which does not come under state government Lokayukt police wing to submit a report after inquiry under 202 and secure the presence of accused, then to refer complaint under 156.3 read with 175.3 of the BSSS police Lokayukt for investigation and submit report, take cognizance, punish them in accordance with law. Why should your lordships not even spend a minute on this matter? Just because, my lord, it's going to embarrass a sitting chief minister. But if this is the kind of conduct of a complainant petitioner before your lordships, I don't think your lordship should show indulgence and hear him at length and not allow him to rely upon judgments without actually pointing out these facts in his own complaint. Not one word about it. Suppressed. The attempt is to mislead the court in passing an order. Lord, I have a great, serious reservation about the conduct of this petitioner. I don't think your lordship should these powers under 226 are not meant to be exercised at the behest of these kind of persons. So, my lord, I respectfully submit that this complaint, now please see my reply. My lord, what he has done. Turn to my reply, my lord. It's shocking, my lord, what this petitioner has done.
Yes.
Kindly turn to my reply, para 1, lady C. Lord, this is reply on behalf of respondent 12.
Yes, sir.
It is submitted at the outset that judgment dated 24th of September on which present proceedings are principally founded. Lord, I'll come to his writ petition a little later. Is extraneous and unsustainable. Original complainants who were parties before the Honorable Court in the said proceedings are guilty of suppressio vera and suggestio falsa in their governments in complaint before the special court and application for prior approval before the Honorable Governor. Aforesaid judgment is, however, rendered by reference to the said documents which form part of record before it. Crucially, the answering respondent was neither made a party nor heard during the said proceedings. Crucial facts which are not considered by this Honorable Court include the following. Now, just see these facts below. 1. Answering respondent's title. Much after relinquishment of the subject land in favor of answering respondent's elder brother in 1968, his legal heirs and answering respondent's other brother Malaya relinquished their rights in the said land in favor of answering respondent. The same was done in view of the answering respondent having discharged the debts availed by his deceased brother and to secure which the land had been mortgaged. A copy of the instrument recording relinquishment of rights in favor of answering respondent is produced herewith. Now, this is before the authorities. Just turn to 12 by 1. Kindly turn to 12 by 1. Tell me what it is in Kannada, Aditya. What does it record? Read for lordship's convenience. Which part is? Page 35 is the translated copy, my lord. This is before whom? Which authorities? This is before the mutation authorities, my lord. So, my lord, this document was available on record. Kindly note this. He selectively not hides this document. He selectively hides this document because his entire case is based on this, that my client had no right, title, and interest.
Dave sir, one moment.
Yes.
In your paragraph 13, 14 and 15, is this correct?
What?
Is the petition filed on the same day FIR is registered?
Yes, my lord.
On the same day?
Yes.
Because you have said FIR is registered on 27/9/24 at 1:15 PM.
Yes,
And on the same day this petition is filed?
Yes.
that's correct.
Lord, it's a gross abuse. Your lordships have, Lord, I don't know why your lordships have not been told facts. This, my senior told me, my lord, first day when I joined bar in September of 1978, that Dushyant, know your facts well. Law will take its own course. And he came to be, my lord, one of the finest judges of the Supreme Court, Justice S.B. Majmudar, who was, my lord, Chief Justice of your lordship's court.
Yes, yes, court here also.
Next page, your lordship, may kindly say, my lord. The 2 days, 27/9, both sequence of events with regard to pursuant to your lordship's order and local complaint being given.
Yes, sir. Dave sir, continues.
Yes, my lord. Kindly turn to page 35, my lord.
Page?
41. Relinquishment, it is at 41. What
Yes.
Aditya, what I am referring to is para 1.
Correct, sir. You read 41.
41, my lord.
Yes.
41. Lord, please turn to 41. It's in English?
One other aspect, my lord.
Yes, my lord.
Complaint was filed at 11:59 in the morning itself. Read petition. Immediately after filing the FIR. The timing is also very important.
How did you get that?
It's in the website itself,
All right.
High Court website.
We'll see. Yes.
11:59 in the morning.
My lord, technology has its own advantages and disadvantages.
ಏನು ರಾಹು ಕಾಲ ನೋಡ್ತಾ ಇದ್ರ
ಅಲ್ಲ,
ಅವ್ರು ಹಾಕ್ತಾರೆ.
ಅವ್ರು ಹಾಕಿರೋದು, ನಾವು ಹಾಕಿರೋದು.
Now see page 41, my lords. Before the revenue inspector, Mysore Taluk, residents of house number so-and-so, Sri late Ninga Jivara, first son of Malaya, late Malaya, his wife so-and-so, and their son so-and-so, Mysore Taluk, land survey number so-and-so, so-and-so, transfer application form 19 filed by late Ninga Jivara, son Devaraju. That's my client. Said land belongs to Ningra Jivara. Currently, it has expired. Said land is not portioned amongst them. Already, we have sold 4 acres, belongs to our family. We don't have any objection to transfer of Katha of the said land to Devaraju, written as stated in oral statement. We have read and listened and given statement. It's correct, agreed and signed. But this is a vital document which has been withheld. I am sorry to say that your lordships have been taken for a ride. No, my lord, it pains me. Because if this was not told to your lordships would not have recorded a finding against me that I had no right, title and interest, and yet I proceeded to sell the land. But this was a family settlement. My lords are aware, Kale's judgment of the Supreme Court, Justice Krishna, brilliantly speaking, why court should adhere to family settlements. My lord, there were debts incurred by the family. I came forward and said, I will discharge those debts. The lands were mortgaged. My one surviving brother and another brother's widow and